Cabral versus Bracamonte, GR number 233174, January 23, 2019. This is for criminal procedure, specifically on who may file crimes but cannot be prosecuted de officio. Subtopic: Persons who must prosecute criminal actions. Question: Who is the real party in interest and who can represent the people before the Supreme Court? Answer: In criminal cases, the people is the real party in interest, and only the Office of the Solicitor General can represent the people in the criminal proceedings before the Supreme Court. The private offended party is but a witness in the prosecution of offenses whose interest is limited only to the aspect of civil liability. Facts of the case: This case was about the personality or legal standing of the petitioner to question the Court of Appeals decision. This was an original case for estafa filed by petitioner Ruel Francis M. Cabral against respondent Chris S. Bracamonte. The prosecutor found probable cause for estafa and filed the same with the Regional Trial Court of Parañaque City. The respondent, Bracamonte, filed a motion to quash with the Regional Trial Court and argued that the venue was improperly laid because the post-dated check was delivered and dishonored in Makati City. Thus, the prosecution failed to show how the supposed elements of the crime charged were committed in Parañaque City. On the other hand, the petitioner Cabral maintained that the averments in the complaint and information are controlling to determine jurisdiction. The regional trial court ruled in favor of petitioner Cabral and denied the respondent's motion to quash. However, the Court of Appeals set aside the regional trial court's order and dismissed the information against respondent Bracamonte due to lack of trial court's jurisdiction, as all the elements of the crime occurred in Makati. Aggrieved, the petitioner Cabral filed a petition for review on certiorari under Rule 45 of the Rules of Court, assailing the Court of Appeals decision. Petitioner Cabral argued that the jurisdiction of courts in criminal cases is determined by the allegations of the complaint or information and not by the findings the court may make after the trial. That the crime of estafa is a continuing or transitory offense which may be prosecuted at the place where any of the essential elements of the crime took place. And finally, that the motion should be considered barred by laches as it took respondent 4 years before he raised the issue of jurisdiction. Issue: Whether the Court of Appeals was correct in dismissing the information against respondent Bracamonte. Ruling: Yes. The Court of Appeals was correct in dismissing the information against the respondent. On the procedural aspect, the Supreme Court deemed it necessary to note that petitioner Cabral filed the petition without the participation of the Office of the Solicitor General. Time and again, the court has held that the authority to represent the state in appeals of criminal cases before the Supreme Court and the Court of Appeals is solely vested in the Office of the Solicitor General. Section 35, Paragraph 1, Chapter 12, Title 3, Book 4 of the 1987 Administrative Code explicitly provides that the Office of the Solicitor General shall represent the government of the Philippines, its agencies, and instrumentalities, and its officials and agents in any litigation, proceeding, investigation, or matter requiring the services of lawyers. The private offended party or complainant may not take such appeal, but may only do so as to the civil aspect of the case. The Supreme Court said that there have been instances where they permitted an offended party to file an appeal without the intervention of the OSG, such as when the offended party questions the civil aspect of a decision of a lower court, when there is denial of due process of law to the prosecution and the state or its agents refuse to act on the case to the prejudice of the state and the private offended party, when there is grave error committed by the judge, or when the interest of substantial justice so requires. In this case, however, the petition before the Supreme Court essentially assails the criminal and not only the civil aspect of the Court of Appeals decision. Thus, the petition should have been filed only by the state through the Office of the Solicitor General and not by petitioner Cabral, who lacked the personality or legal standing to question the Court of Appeals decision. This is especially so because, as discussed by the Supreme Court, the dismissal of Cabral's complaint was not gravely erroneous, nor did it amount to a denial of due process of law that would allow the application of the exceptions mentioned. Therefore, the Court of Appeals was correct in dismissing the information against the respondent. In applying the foregoing, the petition was denied and the case was dismissed without prejudice.